Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. Okay, today I will tell you about sea law, the Jones Act, and the need to retain a maritime lawyer. This article was written by Elias Rodnikas. The increasing development of international maritime trade, combined with a steady growth in tourism, are driving an increased demand for maritime workers to staff both merchant ships and cruise vessels. More than three-quarters of freight shipped worldwide is said to travel by sea. The global merchant fleet includes some 80,000 vessels of at least 100 gross tons. More than 1.2 million seafarers are currently manning these vessels worldwide. It is common to hire mariners from different countries. Many seafarers work in ships not registered in their country of origin. Such mixed crews often do not speak the same languages. Both on land and at sea problems often arise from work and life on these ships. Legal disputes that originate on board have unique characteristics that can differ significantly from problems that originate on land. Things get even more difficult when trying to find what specific maritime laws will protect workers or passengers in each situation. Why is it so difficult to know which maritime law applies? Many factors come into place when deciding when maritime laws are appropriate in each case. Among other things, one factor to consider is the location where an incident happened. Did it occur in territorial waters or the high seas? The flag of the vessel in which the incident happened is also important. Even the location on board the ship is often established within given applicable contract, and whether an incident occurred in public passageway or in areas given over for the operation of the ship can be relevant. Further, complications arise from the fact that passengers and crew are often from different countries, with differing languages, cultures, and laws. These difficulties are often used against passengers and crew who feel as though their rights are quickly disappearing. Although workers and passengers may feel helpless, it's important that they understand that their right can be asserted. And then let's take a look at maritime law and the Jones Act. After exposing some of the problems of maritime law, it is important to be aware that it is possible to claim compensation for damages. To cite one example, the Merchant Marine Act, known as the Jones Act, was passed by the U.S. Congress in 1920 and protect both U.S. and foreign-born sailors. Mariners can claim injury compensation provided that their employer has not provided a safe workplace. An accident claim may have not even originated on the boat. The Jones Act protect employees from marine employer negligence, however minimal. Not only sailors are protected by maritime law, disputes arising out of the business relationship between passengers and cruise companies can also be argued within the framework of maritime laws. Several reports of sexual abuse on cruise ships and disappearance cases involving persons at sea have been covered, where often people were not aware of the existing maritime laws created to protect victims of just such cases. In every case, it's important to know that the unique characteristic of maritime law can be complex. The assistance of an experienced maritime lawyer cannot be overemphasized. Only those receiving through professional and learned counsel are likely to successfully see their right asserted and just compensation served. And then the next is, what is the Jones Act? Well, in 1920, the effort of Senator Wesley Jones led to the approval of the Merchant Marine Act, which is remembered and recognized even today as the Jones Act. This federal law has a strong protectionist theme to it, in accordance with the historical situation in which it was written. In this sense, in the first part of the Act, it established that the vessel which fly a U.S. flag must be owned by U.S. companies and be registered in the country. And at that time, there were attempts to increase the vessels of construction and maintenance of boats with U.S. ownership and crews. As has been shown, the Jones Act was aimed at protecting the United States maritime industry. However, its content goes beyond this first objective and gains great importance because of the way in which it protects in a specific way the right of the seaman. Putting into law some old traditions and practices which look to protect the crew member economically in the event of them being injured at sea. It is important to point out that before this law was introduced, any seaman who was injured while working had a very limited possibility of receiving a fair amount of compensation, while they would often lose both their current job and future opportunities due to the injuries. As a result of what we have just seen, the Jones Act is mainly focused now on the demand which it places on employers to compensate crew members for the costs which result from accidents which have happened on board a boat. And then, who is protected by the Jones Act? It is vital to point out that, taking into account the current legislation, we will use the name seaman for any person who is employed to take part in any type of work or to carry out any type of role on board a seagoing vessel. Except for scientific staff, sailing school instructors, and school students, the definition of seaman is wide, and as such, the Act protects all of the maritime workers who carry out their jobs as crew members on a U.S. vessel. And then, benefit for the injured seaman. The Jones Act gives the employer an obligation to pay the transport costs for moving the worker from the boat to the place where they will receive medical treatment. In the same way, the employer has the obligation to pay the costs, such as hospital, doctors, medicines, and other related costs. It was relating to the medical attention received by the injured crew member, regardless of who was to be blamed for the incident which led to the injury. The Act also states that in the case of employer negligence resulting in an accident to a worker, they must pay the lost salary payment. The injured worker could also claim against the employer for the payment of lost salary in the past and in the future. They must also pay the injured crew member a daily amount for living on land, which is equal to the amount that would have been spent by them living on board. If the worker dies as a result of the accident, there are also benefits laid down for the members of their family. So it is important that we emphasize the fact that in all of the cases where negligence or lack of responsibility on the part of employer has been proven, the compensation will be greater. Generally, it is necessary to demonstrate that the incident happened because the vessel was not seaworthy, because it was in bad condition. However, the seaworthy element can also be related to the fact that the employer didn't have properly prepared crew. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe this channel. See you in the next video, and bye bye.